everyone. My name's Megan Risser, and my case is over Brown versus Entertainment. So I'll go ahead and start with a little background. So, just some background: the case Brown versus Entertainment was decided in 2011, but the law that California tried to pass was actually created in 2005. So that just goes to show you what a lengthy process that was. The who is Edmund Gerald Brown, the governor of California. When the law was first passed, the case actually began as Governor Schwarzenegger versus Entertainment, but was renamed because Jerry Brown, the governor, was elected in 2010. So they renamed it to Jerry Brown. But you'll see later in the facts that it was Governor Schwarzenegger who filed for an appeal of some rulings. So, and then Entertainment Merchants Association, which is a non-for-profit international trade association. So they're dedicated to advancing the interest of the home industry, and I'll give you a little more information about the EMA. So the EMA was established in 2006, but like I said, the law that California tried to pass was created in 2005. So the EMA actually emerged from the as a result of the law trying to be passed. It was a merger of Interactive Entertainment Merchants Association and the Video Software Dealers Association. And so those were just two separate organizations that came together to create the EMA, and their mission is to promote, to protect, and provide a forum for the common business interests of those engaged in the sale, rental, and licensed reproduction of entertainment software, so movies, video games, TV shows, etc. So the facts of the case. So, like I said, in 2005, California passed a law restricting the sale or rental of violent video games to minors and required an additional labeling to the video games beyond the ESRB label, which I'll explain later on is the label that kind of video game companies already put on the packaging. And this act covers games involving killing, maiming, dismembering, or sexually assaulting an image of a human. And so before the bill was even signed into law, the associations were preparing a lawsuit. So when I say the associations, that's all of these media industries as organizations before they merged together as the EMA, so they were referred to as the associations. And then in August 2007, the district courts ultimately ruled for the plaintiffs. So the associations essentially believed that the act violated minors' First Amendment rights, and they were also worried as to if this law was passed, how would that affect the media industry in the future as technology evolved. So in 2007, the district courts ultimately ruled for the plaintiffs, the associations, but then in 2007, so September of 2007, literally a month later, Governor Schwarzenegger filed for an appeal stating he would vigorously defend the law because he believed that the people of California had a responsibility to protect their children. So he felt very passionately about this. And so he filed an appeal in 2007 in the Ninth Circuit courts, but that appeal was overruled. But, like I said, he was very persistent. And then 2 years later, May 2009, Schwarzenegger filed a writ of certiorari, sorry, I have such a hard time saying that word, to the U.S. Supreme Court to overrule the Ninth Circuit rulings. And the U.S. Supreme Court actually agreed to hear this case, which raised a lot of questions for people, mostly because it was very surprising. Similar cases had been brought and were unanimously overruled, so they were surprised that this case was agreed upon to be heard. And then like I said before, the case started as Schwarzenegger v. the EMA, but then was renamed to Jerry Brown when he was elected in 2010. So the issue and holding is, did California's law restricting the sale or rental of violent video games to minors violate the First Amendment? And the courts found that yes, it does violate the First Amendment. The majority reasoning was given by Justice Scalia, And it was like protected books, plays, and movies that preceded them, video games communicate ideas. This suffices to confer First Amendment protection. So Scalia believed that video games, like other media, were a way for people to communicate some sort of message. And like in, so I'll read the justifications, but the First Amendment, you can't limit First Amendment rights based off of content. So the government has no power to restrict expression based on its subject matter. New categories of speech cannot be added to the list. Number two, there is no tradition in this country for specifically limiting children's access to violent messages. One of the big examples that he used was the Grimm Brother fairy tales. Children have access to those, and if none of you know, these fairy tales are particularly gruesome. I think in the original Cinderella story, the stepsister's eyes get pecked out by a dove. So his thing was is that like high schools allow children to read these books and they have access to them and no one's putting a limit on it. Number three, California's act does not pass strict scrutiny, which means it's not justified by a compelling government interest, and it was never narrowly drawn to serve such an interest. And then number four, the act is under-inclusive and does not include other forms of media and shows no evidence of meeting standards the ESRB label doesn't already provide. So I have pictured above the mature 17 plus. That's the label that video game companies already put on a video game. So he was saying that this act doesn't really seem to just, provide parents with anything beyond what video game companies are already providing them. So the concurrence and dissenting opinion. The concurrence was given by Justice Alito. He said the decision was correct, but the reasoning was not. He warned that the court should be careful as to not assume violent video games are just like any other form of media, and I'll talk about that later. That kind of became a very two-sided argument. A lot of people were either, one side or the other. And then the first dissent was given by Justice Thomas. He said, historically, intent of the First Amendment does not include a right to speak to minors without going through the minor's parents or guardians. So in his opinion, we're already using parents to we have to go through parents to speak to minors. So he didn't believe that this was really a restriction on their rights. And then the second dissent was given by Justice Breyer, who believes it to be less about censorship and more about education. So he firmly believed that the government has an interest in permitting parents to make decisions for their children. So that's where he thought it did pass strict scrutiny. So the significance of this case, it kind of touches on the latest technology and entertainment. So this was a big deal in the sense that video games aren't like books, they're not like movies, they're their own form of technology. And as the times go on, obviously when the First Amendment was originally created, video games weren't a problem. So this was an example of how as technology progresses, laws are going to surface and we're going to have to decide, does this violate the First Amendment rights? And it's kind of up for the court's interpretation. And then another big thing was the opinion shows a tension between treating a video game like any other kind of media or as a unique form. So the uniqueness about video games is that they have an interactive and a fully immersive element, unlike books or movies, some people say. So that is kind of like a clash. And that was the question I wanted to pose to you all, which was, do you think video games should be treated like any other form of media and they cannot have laws restricting their messages based on content? Or do you think they're a unique form because of the immersiveness? Kids get to actually be a player performing these acts. Because of their uniqueness, do they require additional restrictions? So that was Brown versus Entertainment. Thank you all for listening, and let me know in the comments what your guys' opinion is.